Looks like we're waiting on Judge Klee. Mike, do we know if Judge Klee is there?
I am sorry.
There he goes. All right. Good afternoon, everybody.
Good afternoon. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh, yay, oh, yay, oh, yay. All persons having any manner of form of business before the Honorable, the judges of the United States Court of Appeals, I admonish you to give their attention, for the court is now sitting. God save the United States and its Honorable Court.
Well, we can't start till Mr. Coleman tells us we can start, so I was a little bit jumping the gun there. Well, welcome to the Fourth Circuit for our afternoon session. We're doing this by video. I did one this morning, and we had a few technical problems, so hopefully they're all worked out. If not, Mr. Dean will be on the phone with you, and we'll continue by telephone if we can't do it by video. So that said, our first case today is Wayman Tom versus Hospitality Ventures, and we'll hear from Ms. Hernandez.
Good afternoon, and may it please the court. Jill Hernandez on behalf of Appellant Wayman Tom. And please let me know if I'm speaking too loudly. I will be reserving 6 minutes for rebuttal. Your Honors, coincidentally, yesterday was about celebrating workers' rights in this country. And this case is about protecting some of those rights. At its core, this is a tip credit case where the appellees operated an illegal tip pooling arrangement, permitting non-tipped employees to participate, thereby violating FLSA's wage requirements. When confronted with this lawsuit, the appellees promptly forged a narrative to evade the requirements of the FLSA by retroactively reclassifying certain gratuities as service charges and applying Section 207I of the FLSA. To uphold such a scheme and accepting appellees' artificial justification would undercut one of the fundamental purposes of the FLSA, ensuring that workers are adequately paid as required by the FLSA. As such,
Ms. Hernandez,
yes.
If I could interrupt you just for a second. You just mentioned the classification designation as a service charge, and there's discussion in the briefs and discussion in the order about the 7I exemption. And my first question is whether, in your view, a service charge under 29 CFR 531.55 is the same concept as a commission under 7I, or are those different concepts, or are they used interchangeably, or are they different?
That is an excellent question, Your Honor. And for purposes of this matter, they are different. Here, the auto gratuities are distinguishable from service charges, as they were not compulsory, inflexible, and non-negotiable as required by the applicable regulation 531.55. And for example, in the McFeely case versus Jackson Entertainment, this court provided some initial guidance identifying at least two prerequisites that indicate a payment may be a service charge. The company must include the service charges in its gross receipts, and that such service charges must be distributed to its employees. Now, in McFeely, because the employer failed the first prerequisite no further assessment of whether the service charge was in fact a bona fide fee or a tip was necessary.
Counsel, in this case, those prerequisites mentioned in McFeely have been met. Is that correct?
Actually, Your Honor, they have not been met. While the appellees failed to include a statement of undisputed fact regarding the service charge or proof that service charges were included in the gross receipts, even if those auto gratuities at issue in this case were included in the gross receipts, there are still additional factors that should be considered in determining the compulsory nature.
That's not my question. My question is, you have these two prerequisites in McFeely. Now, whether or not there are others, that's part of what we'll discuss today. My question to you is, are these two prerequisites met here?
Your Honor, the answer to that question, respectfully, is no, because the appellants did not include a statement of undisputed fact relating to whether or not the service charges were actually included in the gross receipts. So while the appellant did not necessarily oppose the statement of fact because nothing existed as it relates to the service charges, it wasn't also conceded. It has been argued in response in the appellate brief, and so we would contend that the first prerequisite was not met in this matter.
So I understand what you've said now. Is there anywhere in your briefs that you note that these two prerequisites were not met?
We do address in some aspect that there was no indication, no statement of undisputed fact included. Unfortunately, right at this moment, I'm looking for that information. And Your Honor, as soon as I'm able to retrieve it, I can communicate that to the court.
Why don't you look for it and you can tell us on rebuttal so you can proceed with the rest of your argument.
Thank you very much, Your Honor. I greatly appreciate that.
And before you do, Ms. Hernandez, I'd like to just follow up a little bit on my earlier question. So it does not look like the service charge regulation has the requirement that the service charges have to be 50% or more of the workers' compensation. That is in the 701I exemption. And that's my question as to if we assume that this is a service charge and it meets the two McFeely requirements, do we even need to be talking about 701I?
Well, for purposes of this matter, Your Honor, the appellees contend that because the service charges basically constitute commissions, that 7I does apply. But because of the authority that around the country, and there's quite a bit of authority around the country that has analyzed the context of service charges and determining whether there's a discretionary nature, has found that any indicia of evidence that would demonstrate that the service charges are discretionary would be grounds to deny a motion for summary judgment.
Sure.
Therefore,
I understand your argument about there being a genuine issue of material fact. I've read that, and I appreciate the cases you've cited. And I recognize that the employer has focused a lot on 7I, as did the district court. I'm simply asking, why are we doing that? I mean, a service charge seems, as I read it, to be, a requirement that does not have some of the limitations. And if you assume, and I know you don't agree this, that there's no genuine issue of material fact about discretion, why does that not end the inquiry?
Well, Your Honor, it certainly doesn't end the inquiry because it would essentially negate the application of the 203M. And here, all of the evidence supports that the employer actually had, or essentially was utilizing the tip credits, not 7I. And yet, to circumvent the requirements of 203M, the tip credit, it created or essentially reclassified these auto gratuities, which are nothing more than tips, to call them service charges, and therefore to bring in 7I. So then 7I would apply as an overtime exemption, negating the minimum wage and negating the overtime. I hope that answers the...
Yeah, let me follow up on that. Now, I'm sorry to be kind of stuck on this, but I'm just actually trying to understand it. I mean, is there prior to a lawsuit or prior to a complaint, is there something where the employer designated the way they meet the FLSA as being either a tip credit or a service charge? Is that something that you must do as you go along? And are you saying they changed it after the fact? Or is it something that if you're challenged, you can meet it under any of the available ways?
Your Honor, that is an excellent question. And to answer your question, I would direct the court to Section 203M of the FLSA, which the appellees here. Now, Section 203M directly relates to the tip credit. The appellees advised the servers in writing, as required by 203M, that they were going to be paid $2.13 an hour plus tips, not plus commissions. The onboarding paperwork explicitly excluded commissions as a form of income, thereby demonstrating that their wages would be earned through a direct hourly wage of $2.13 an hour, time and a half for hours over 40, as high as $5.88 per hour. And the FLSA states that the employees' tips are their property. So the servers in this case were paid time and a half, $2.13 an hour, and as high as $5.88. So I hope that addresses the court's question that yes, pursuant to 203M, the appellees did comply with instructing and advising the employees through a handbook and in writing and onboarding paperwork that they were tipped employees subject to 203M and that they would be paid $2.13 plus tips.
Counsel, I'm sorry, Mr. Cattlebaum, go ahead.
No, go ahead, Judge Clay. You go ahead.
I guess my question, counsel, is that information conveyed by the employer to employees dispositive? Or can an employer, whether they intend to or not, back into FLSA compliance even if they provided inaccurate or arguably misleading information at the front end?
So this information is obviously dispositive. It's in the record. In fact, the other interesting point, Your Honor, is that during the course of deposing the appellee's corporate designee, who testified under oath that he was responsible for implementing the appellee's payroll practices and policies, he testified that he had never even heard of 7I until 1 week before his deposition in preparation for the deposition, which I think is dispositive that the appellees actually just try to recreate a narrative to circumvent the requirements of 203M by applying and reclassifying certain tips as service charges and then backing into the 7I to be considered overtime exempt.
But is there anything, counsel, in the regulations that requires the employer to pick their lane, so to speak, for FLSA compliance and stick with that no matter what? Or does the employer have the ability to meet the minimum wage and overtime requirements, whichever way the facts take them?
That's an excellent question, Your Honor, and I must say that, unfortunately, as I mentioned at the outset, to allow an employer to simply to allow that scheme where the employer can simply change the pay practice, even though throughout the course of the appellant's employment, they were communicated to be tipped employees and subject to 203M and pays 213 plus tips would obviously allow all of these employers to evade the requirements of the law if they simply were going to pick and choose when confronted with a lawsuit of another way to comply with the law.
Look, if I could just follow up on that last one,
Sure.
please, Judge Agee.
Go right ahead.
Counsel, how is it evading the law if, I get it, it's going in a different direction from including tips, but the law, I thought, was designed to make sure that they get the minimum wage, number one, and number two, get time and a half if they work over 40 hours. And if they're getting that by virtue of including service charges, how are they evading the law? It seems to me they're giving the employees what the statute is designed to give them.
Well, again, Your Honor, because at the outset they were not advised that they would be paid, commissions, or that somehow commissions would be a form of income, including, the suggestion that somehow once they adopt the gratuities as service charges, it completely negates the requirements of 203M. I think that would be a huge disservice to millions of employees in the restaurant industry, because now you would have employers that on the surface would appear to adopt a tip credit, paying these people less than minimum wage, paying them time and a half, $2.13 an hour, and then when confronted with the lawsuit, completely switch gears and do a 180 and then adopt a completely different set of parameters or exemption under the FLSA to appear to be in compliance.
Thank you very much.
All right, thank
You're
you,
welcome, Your Honor.
counsel. And you've got some time reserved for rebuttal. Mr. Hunt, we'll hear from you.
Thank you, Your Honor. To follow up on one of the questions that the court asked, this is a case obviously under the Fair Labor Standards Act, and compliance under the Act can vary from pay period to pay period and go in and out. There's nothing that prohibits employer from using the 7I exemption or using a tip credit. And in this situation, what happened was, as the district court found, the employer properly used the 7I exemption. To further follow up, the two requirements in McFeely were clearly met here. There's evidence in the record. It's in Mr. Remy's declaration. It's at volume 6, page 2221, where he describes that the service charges went into the gross receipts of the defendant. And in addition to that, they paid the North Carolina sales and use tax on the service charges. So these service charges, these commissions, were completely treated in a proper fashion pursuant to 7I.
Counsel, if I could, I want to go back to the question I was asking your colleague. I mean, you're referring to 7I, and I understand that argument. I may have a question or two about that. But is the service charge under 531.55 necessarily the same as 7I? Why aren't you arguing this is a service charge without regard to a commission under 7I?
Well, I think, Your Honor, I think the two are in our opinion, I think the two are the same. The regulation speaks to the service charge under 7I. And
so you think I'm sorry, you think the regulation is interpreting 7I so that those are essentially one and the same?
I believe that it does. It talks about what the service charges are. I don't think there's a difference between the two.
Well, okay. Yeah, 7I has two things. Let me follow up on that then. I mean, 7I appears by its text, if I'm not reading it incorrectly, to apply to the overtime requirements. It doesn't say anything about the non-overtime minimum wage. And so That's why, and it also has the requirement of the 50% of compensation, element. And I know you think you established that, and you may be right, but is there anything authority-wise that says service charge under 531.51 is the same as a commission under 7I? Or is that just y'all's interpretation?
Well, I think that to an extent has been the way the courts have interpreted. For example, the MECMET decision, which came out of the Seventh Circuit a number of years ago.
Right.
That,
Sure.
I think, that basically equated the service charge to the commission. And even before that, actually, and I think we cited this in our brief, going back to 1976, there was an opinion from the Wage and Hour Administrator regarding the use of service charges in the hospitality industry, and basically reached the same conclusion that they did in MECMET. So I think that there's been a pretty consistent equivalence between the service charge and the commission, at least the service charge in the hospitality industry, and a commission under 7I. That's, I think, the courts and the Department of Labor have both viewed it that way. And in the hospitality industry today, that's probably the most common way of compensating employees that work for example, in the banquet department of a hotel, or as was the case here with a restaurant that specializes in large groups or business groups. That's what sort of made the facts in this situation somewhat unique, in that basically had a large number of businesses, large number of business activity, large number of groups. In fact, the restaurant wasn't even open on the weekends except for dinner on Saturday night. They derived most of their business from groups that came in during the week. And that's why...
Counsel, if I could.
Yeah, sure.
I apologize for interrupting your train of thought, but if the focus is going to be on Section 7I, how, if you look at Section 779, 415, talking about the compensation, where we're having to assess this 50% requirement, how are tips not part of all compensation paid to or on behalf of the employee as remuneration for his employment during the period?
Oh, because, well, for one thing, first of all, the tips are property of the employee, not property of the employer. So they're actually...
Are they here because the appellee used a tip pool?
They did use the tip pool to distribute the service charges and the tips. But with respect to why you don't count the discretionary tips, those tips are only counted if you're using a tip credit. And here, as the district court found, there was no need for the employer to use a tip credit, because if you add the amount of the service charges plus the cash wage that the employees received, it always came out to be, or for the most part came out to be, more than time and a half the minimum wage. And it was also more than...
If you don't count the tips, the traditional tips. Right?
Correct.
There's no dispute that if the tips are included in the total compensation, then the service charges don't hit that 50% threshold. Is that right?
I think in that case you'd have to go back. We'd have to go back on a week-to-week basis. There may be some where that might have happened, but our position is you don't include the tips, as the district court found, and we also submitted an affidavit from a former wage and hour examiner to the effect that the tips don't go into that calculation. The employer does not use the tips, and they are the employee's property.
But there's no specific regulation or specific ruling from the Wage and Hour Division that resolves that particular question?
Well, Your Honor, I think that there's, with respect to the proper characterization of tips, the language in, I think it's 29 CFR 531.60, that talks about any tips received in excess of the tip credit are not included in the employee's regular rate because such tips are not payments made by the employer to the employee as remuneration for employment within the meaning of the Act. The tip credit simply is an offset to the minimum wage. So in any event, that those tips are not included for purposes of that calculation. The only
But
thing
is it, but counsel, on that language from 53160, it says you're right, any tips received in excess of the tip credit need not be included in the regular rate. But the 207I, talks that when you're talking about the 50%, it's talking about compensation, not regular rate. So are you using a regulation that's talking about what the hourly rate is and applying that to the concept of compensation?
Yes, because I believe that the regulation regarding the regular rate discusses the employee's remuneration, and therefore that's basically fundamentally equivalent to compensation. So in this case, the compensation is not paid by the employer, that those tips come from the guests. And the guests can leave whatever they want. Now, if it's a large group, which was the situation in most cases here, then it was subject to the 20% service charge. That's a commission, and the employer properly relied on the 7I exemption.
And counsel, if I could, and I'm glad you mentioned 53160 because it was next on my list. I think you're exactly correct. I mean, the language of that regulation is clear. The amount of tips in excess aren't counted toward the regular rate of pay, but the preceding sentence clearly indicates that tips are counted up to the minimum wage. That was a very poorly worded question. Let me try it again. The regular rate of pay includes tips to the extent those tips are needed to get you from your hourly rate to the federally mandated minimum wage. And I think Judge Cattlebaum's point is an excellent one. It seems that we're begging and borrowing from regs, talking about regular rate, and we use it. There's a different word that's used over in 779-415. We're talking about compensation as opposed to regular rate.
But I guess I think the distinction here, Your Honor, would be that in this situation, the restaurant didn't need to use the tip credit. In other words, using 7I, and there's a regulation that says that an employee can be paid totally out of service charges if they meet those requirements. So here, it wasn't necessary for the restaurant to delve into the tip credit, the tip credit and situation, or what that happened to be, or what the difference between the two was, because the amount of the commissions that the employees received plus the direct cash wage that the restaurant paid satisfied the requirements of Section 7I. So
but doesn't the hourly rate that's paid, the $2.13 an hour, doesn't that contemplate they're going to take a tip credit? In other words, can an employer pay a low hourly rate as low as $2.13 an hour and not take advantage of the tip credit? In other words, they can use the $2.13 rate, which contemplates tipped employees and tipped credits, not use that, skip over tips, and use service charges instead. I mean, can an employer meld those two concepts, leaving tips out of the picture?
I think under the correct circumstances they can, because, like, as in this situation, because you had so much group business and the commissions were so high and the service charges were so high that yeah, you could pay a direct wage of $2.13 or $2.50 or whatever they chose, but so long as the commissions were high enough to come in at time and a half the minimum wage, in which the plaintiffs readily admit they admit they were paid more than time and a half the minimum wage throughout their employment, but so long as those factors obtain, then I think an employer could. But I think in a lot of cases, if, for example, if you had perhaps a restaurant that maybe didn't charge as much, had less group business, the ability to use the service charge is going to be very limited. I mean, they're just not going to have the big ticket items, as they said in some of the other decisions, that you had in this situation, that you had it on. And I think that's the distinction between those two scenarios.
Well, counsel, your opposing counsel has argued that what we see now on appeal and presented in the district court with the use of service charges, the auto gratuities, is not what was originally placed on the employer's books when the employees started. What's your response to her argument there?
Well, first of all, Your Honor, as I said, we submitted evidence that the service charges were booked properly and the employer paid the taxes. The fact that the employees may have been told that there was a tip credit or that they were getting 213 in a direct cash wage, we think is irrelevant because because wage and hour laws really depends on what actually happened. And what actually happened in this case, the actual circumstances on a pay period by pay period basis were that the amount of the service charges were sufficient to comply with 7I. And part of that, at least the time and a half requirement, the plaintiffs admit to. The plaintiffs, therefore, were paid the minimum wage. They were paid more than time and a half, and most of that came from the service charges.
Well, your opposing counsel hasn't breached this part of the argument from brief yet, but I assume she will, and I wanted to give you a chance to respond. The argument is made that there is a material issue of fact because the service charges were not compulsory or controlled by the employer, but that they were discretionary, and that there's evidence in the record that on various occasions when there were complaints, the service charge would be removed. So what's your response to why that isn't a material issue of fact that would preclude summary judgment?
Well, first of all, with all due respect to opposing counsel, I don't think there is evidence in the record of that. First of all, plaintiff Tom, who's the principal plaintiff here, testified that there were no complaints at any time by any customers about the service charge. That was in his deposition testimony. What happened on a handful of occasions, according to the record, was that the individual servers, or at least two of them here, maybe Mr. Kelly and Tom, asked to have the service charge, would ask the manager to remove the service charge. And the reason for that was because they felt they could get a bigger tip from the party rather than the straight application of the 20%. That's why, that was the only circumstances when it was removed. But it wasn't pursuant to a customer complaint. In fact, I think this situation is very distinguishable from some of the cases that counsel cited in her brief, where right on the invoice or right on the guest statement, the restaurant would say this is a suggested gratuity, or if you have a problem with this, you ask your server, they can remove it. You can, if you don't want to pay it, basically you don't have to. That wasn't the case at all. This was a flat, the evidence is, this was a straight 20% service charge on parties of 6 or more. And yes, there were maybe a handful of occasions where one of the servers asked to have it taken off, but it wasn't one of the customers. So for that reason, Your Honor, I don't think that rises to the level of a disputed material fact.
So in those instances where the auto gratuity was removed and a traditional tip was given, was the tip counted as part of the auto gratuities and included in the employer's gross income, or was it counted purely as a tip and attributed to the employee?
In those situations, it would have been counted as a tip and attributed to the employees because there would have been no service charge and wouldn't have been any revenue to book on. So that would have been treated as a tip. But again, this was a handful of situations. The appellants have argued that and secondly, the appellants have argued that the tip credit, or excuse me, the service charge has to be flexible. It has to be this kind of fee that's always imposed. The cases really don't stand for that. What they really stand for, and first, I don't think there's any case that says that the service charge has to be flexible. What they actually stand for is that if you have a system where the service charge is suggested, or it's recommended, or the practice is such that anytime a guest complains, it can be removed, then in effect, it really is operating as a tip, and therefore it ought to be treated as one. But that's not the situation here. That simply isn't what happened. And as I said before, there's no evidence in the record about any guest ever complaining about the service charge, or the restaurant ever removing the service charge in response to the complaint.
Counsel, anything else you want to tell us before your time runs out?
Yes, Your Honor. I think with respect to the duties with regard to the and the appellant spent a fair amount of time on this in brief with respect to the sushi chefs and the work of the gentleman who expediter. I think it's pretty clear that both of those, the expediter and the sushi chefs, both were directly involved in the stream of service at the restaurant. With respect to the sushi chefs in particular, there's abundant evidence that they interacted with guests, they greeted customers. There's a Department of Labor opinion letter that talks about how sushi chefs can be included in the tip pool. People would converse with them when they would
Here we're not. This isn't an issue about the sushi chef. It's about the helper. There isn't an issue here about the sushi chefs that I recollect.
Well, I think
about
that
their helpers.
Yeah, I think the terms have been used somewhat interchangeably in the record. I think that you've got the helpers and the sushi chefs. There was only one chief sushi chef, and he was a salaried employee, didn't participate in the tip pool. I think the testimony regarding the other individuals, whether they were sushi chefs or sushi chef helpers, can I continue, Your Honor?
Yeah, please go ahead. Finish up that thought.
Whether they were sushi chefs or sushi chef helpers, I think the evidence is that they interacted with interacted with guests. When people would come to the sushi chef bar, they would talk to them. People would ask them questions about what they were doing. It was a real back and forth between the two. And so therefore, I think under any analysis, they were properly included in the tip.
All right.
Thank you very much.
Judge Quattlebaum, Judge Kling, do either of you have any further questions for Mr. Hunt?
I do actually have one, Judge, if I
All
could.
right, please go right ahead, Judge
Need a
Kling.
deficit on time, and I apologize. Counsel, on the issue of the tip pool, if there is someone who participates in the tip pool that shouldn't, does that collapse this entire payroll practice?
I don't believe so, Your Honor. I think it would depend on the extent to which they participate in the tip pool. The other aspect too would be you have to look at the person's activities sort of on a week-to-week basis or pay period-to-pay period basis, because all exemptions to minimum wage and overtime are done on a payroll-to-payroll period basis. So perhaps if there were certain times when the person shouldn't have been in the pool, that might collapse the tip pool. But in this situation, I think the evidence is pretty clear that these folks were properly in the pool.
Thank you very much. Thank you.
Judge Quattlebaum, did you have another question?
Just one last one. I apologize too. The district court talks about how the 701I or service charge or whatever we call it satisfies the FLSA obligations for most weeks, and that for the others, the tip exemption or the tip pool credit satisfies those obligations. And I'm not sure if this is in the record or not, and I'll ask your colleague as well, but is the reason that the service charge commission did not satisfy the obligations for several weeks, is that due to the hourly rate being too low, or is that due to the commissions not being more than 50% of the compensation?
It was due to, there were a handful of weeks where the amount of commissions didn't satisfy the 50%. That's what.
And so if, it doesn't sound like you agree with me on this, and you may be right, but if the service charge is a separate category from 7I and doesn't have the 50% of compensation limitation, would the service charge meet the FLSA obligation, without consideration of the tip pool?
I think it would. I believe it would, Your Honor. I mean, I'm not sure I'm understanding the. In other words, if the employees would still be paid the service charge, but in this case, the amount of service charges they received didn't satisfy the 50% component of 7I. So that's.
Yeah, it might not have been 50%, but it satisfied the wage requirements, both regular and overtime, correct?
Right. It would still right. It would still be considered in that. Right.
Okay, I appreciate it. Thank you, Judge Agee.
All right, thank you. Thank you, Mr. Hunt. Ms. Hernandez, you've got time left on rebuttal.
Thank you very much, Your Honor. There are just a few points that I would like to make. The first is that this court has found that with respect to employers that try to create or follow other sections of the FLSA, such sort of position just cannot be taken. And I'm referring to USDOL versus fire safety. In that case, this court found that employers may not retroactively apply other sections of the FLSA to reach compliance. So that would be my first point. With respect to the 7I and these service charges, which appellees would like to insist are commissioned for purposes of 7I, the applicable regulation that is at issue and instructive is 29 CFR 779.415A, which states that in determining for purposes of 7I whether more than half of an employee's compensation represents commissions on goods and services, you must total the entire compensation during the employment of the individual, all compensation in whatever form or method. And the only compensation that would be excluded is any compensation that has nothing to do with employment. So on this basis alone, those regular gratuities, the direct wages of 213, the overtime, when comparing against the auto gratuities, which obviously appellees are contending are service charges, exceed 50% of the employee's total compensation. In other words, the auto gratuities always are less than 50% of the total compensation. So that's my second point. My third point is...
Counsel,
yes.
Do you have a case that supports the argument that you just made?
Unfortunately, with respect to the calculation of 779.415, there is not that much authority, Your Honor, but certainly the regulation itself was obviously intended as an interpretive regulation to instruct employers on how to utilize and calculate the compensation for purposes of utilizing 207I, the FLSA's overtime exemption. Now, going back to the service charges, there is plethora of authority all around the country that where the service charges have a discretionary nature, have any indicia of discretionary nature versus the compulsory fee that is inflexible and non-negotiable, then the motion for summary judgment must be denied. And while I heard my colleague, Mr. Hunt, suggest that there are no facts in the record to suggest that these auto gratuities were discretionary, that is simply false, because the factors include what is the customer's understanding of the payment. And here, the customer could easily ask to have it removed if they were not happy with the service. In fact, if you look at the court's ruling or opinion, you can see that the district court actually analyzed a sampling of the appellee's customer bill, which showed 20% gratuity. And then it had a separate line below it saying plus additional tip with a line there so that the customer could add more to the gratuity and then a total. By just the plain language, you could see that for the customer, that would demonstrate that it was a gratuity that was discretionary and not a compulsory service charge.
Well, I can understand why the separate line for additional gratuity would be considered that, but I don't understand the reasoning that says the prior line showing the service charge or auto gratuity, whatever you want to call it, how it would affect that.
Well, because if one of the factors is what was the customer's understanding of the payment, and it's one thing if the bill for going to a restaurant and having a party of 6 or more, having a service charge, and it says on the bill that it is a service charge with a percentage, but in this case, it specifically said gratuity 20%. And so if you just look at the plain language and definition of gratuity, it is a tip. And so for the customer, that would imply that the appellees were simply, for ease of reference, recommending a percentage of the tip. Now, additionally, the appellees...
Let me cancel. We're going to give you a couple extra minutes since we gave Mr. Hunt a couple extra minutes. So we may have a few more questions for you. In this case, or I guess any case of this genre, if you have, I'll just make a hypothetical example. Say you have 100 functions at a restaurant, and they put this service charge auto gratuity on the bill for 100 of them, but in one instance, the server comes in and says, I think they're going to tip me 30%. Will you take it off? And management agrees to take it off. Does that doom the service charge to failure in that one example?
Your Honor, that is an excellent question, and the answer is unequivocally yes. And you can see from the plethora of authority around the country that that was the reason why the district court would absolutely deny a motion for summary judgment. Because even in those cases where it just appeared to be a service charge and not some type of gratuity, in this case an auto gratuity, the courts had found that it was merely the minimum, but if they were able to pay more or not pay it at all, then that in and of itself would demonstrate the discretionary nature.
So,
and that is what happened here.
In that example, if this one case out of 100, the food was terrible, the waiters were drunk, they spilled food on the customers, and management takes the service charge off. In that circumstance, you say that one event in and of itself dooms the service charge to be an unregulated tip.
Well, I hear what Your Honor is saying, and my understanding is that you're suggesting that if it only happened once, then obviously it doesn't, it somehow would not negate the service charge compulsory nature. In this case, however,
what we're trying to establish here is the principle of law. So that's why I'm trying to understand the argument on what creates a material fact that's in dispute on the treatment of these service charges / auto gratuities. And I took the argument from your brief to be that there could never, under any circumstance, be a deviation from treating the service charge as mandatory, no matter what the circumstances.
that is correct, Your Honor. That is absolutely correct. Because the service charge regulation states that it must be compulsory, it must be inflexible, and it must be non-negotiable. So not even in one situation where the servers are drunk and the service is terrible can the manager remove the auto gratuity and still be able to assert that the service charge is compulsory. And in this case, the facts demonstrate that it was only applied 50% of the time, and the servers, it was perceived as a server's property because they could ask to have it immediately removed, and the customers could pay more, could pay less, or pay nothing at all. Additionally, the regular tips and the auto gratuities were commingled all of the time, because if there were parties of 6 or more and it had the auto gratuity, and if they added another $100 because the service was impeccable, then it would be commingled, and then it would be added, and all of the servers would essentially split the gratuities through their payroll check stubs, and then it would be taxed as wages.
All right. Ms. Hernandez, you want to try to wrap up in the next minute or so?
Yes, Your Honor. Thank you so much. So finally, after the last issue here, the district court clearly and improperly weighed conflicting evidence regarding the non-tipped employees' duties who participated in the tip pool. There were genuine issues of material fact relating to the kitchen supervisor, who also functioned as an expediter, and the sushi chef helpers. The facts demonstrate that they simply did not engage in more than de minimis interaction with the customers to qualify as tipped employees. And if they did not qualify as tipped employees, then it automatically blows up the tip credit, and therefore the employers are on the hook for the difference between $213 and $725 an hour, and the overtime at $725 to $1088, and then they would also be entitled to their tips, which they illegally had to give up to this invalid tip pool.
Judge Quattlebaum has a question.
Yes.
Yes,
Your Honor.
counsel. In looking at this issue about whether there's a genuine issue of material fact, I appreciate your concern with the district court's language in the first part of the paragraphs making a decision. I mean, there does, in all candor, seem to be some level of, crediting certain types of testimony over others. But the second part, I think, is the issue of whether we have an actual dispute is based on whether it's more than de minimis or not. And just from looking at this, it looks to me like your argument is much stronger on Pappas than it is with the assistant sushi chefs. And my question is whether or not you agree with that or not, and your colleague may disagree with both of it, but if one employee, if there's a genuine issue of material fact over Pappas and there's not over the sushi chef helpers, does that a material issue of material fact for the tip pool as a whole?
Yes, Your Honor. Absolutely. Even if there's one individual who's not a qualified tipped employee, just one, it would blow up the tip credit. Absolutely. It would invalidate the tip pooling arrangement and subject the employer to a violation of the FLSA. And here, the sushi chef helpers were no different than salad preparers. And there is extensive authority from the Fifth Circuit and from various other circuits where even the expos and sushi chefs or sushi chef helpers were found to be non-qualifying tipped employees. So we have that authority that is particularly instructive. But here, even appellees somehow try to suggest that just because the sushi helpers called themselves sushi chefs, that somehow they had the same duties and engaged in customer interaction, and that position is simply disingenuous.
All right, Judge Quattlebaum, Judge Klee, do you have any further questions?
Yes.
No, I do not.
Thank you very much, Ms. Hernandez, and we thank both counsel. Obviously, these are unusual times for all of us because at this point we would be coming down to greet counsel, which you'll just have to consider this your virtual greeting, and hope we'll see you in Richmond when we're allowed to return. So with that, we'll take a short recess while we move on to our next case.
Thank you very much, Your Honor.
Thank you, everyone.
This honorable court will take a brief recess.
Okay, so we get Thomas to come in now. So, Mike, are we all set and ready to go?
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Afternoon, gentlemen. Welcome to the Fourth Circuit. We would prefer to see you in person, but this is good as we can do under the circumstances, so we thank you for joining us by video. And we'll be hearing the case of Food Buy LLC versus Gregory Packaging, Inc. And we'll hear first from Mr. Wood.
Thank you, Your Honor. May it please the court, I'm Bill Wood with the Nelson Mullins firm here on behalf of Food Buy. We're asking the court to reverse the decision of the lower court interpreting the contract in this particular case to provide what turned out to be $7-something million worth of damages. We believe that the lower court erred in its interpretation of the contract, Your Honor, and I'd like to address contract interpretation first. Or the
Mr.
contract
Wood,
interpretation.
Mr. Wood, can you
Yes,
hold
sir.
on for just a minute? Mike Dean, are you listening in? I'm having Mr. Wood's transmission. Visual is fine, but the audio is sort of garbled. All right,
Your
I
Honors,
think-
can you hear me now? I'm sorry.
Yeah, that's better. And I neglected to mention at the outset that since there is a cross appeal, what we'll do after Mr. Wood, after you finish your initial presentation, we'll go to Mr. Ferguson and then come back to you for your rebuttal, and then lastly go back to Mr. Ferguson for his. So with that, please proceed.
Yes, thank you, Your Honor. I was getting ready to say, we believe the district court has misinterpreted the contract in this case. The issue of contract interpretation is one that's subject to de novo review by this court. We believe the way the contract has been interpreted nullifies or makes supersede many of the provisions of the contract. And in particular, the main issue here is whether or not we were allowed under the contract to charge for case or get an allowance, which is defined, I believe, in Section 6 and then in Attachment D, an allowance for a case of juice sold to a committed customer from a distributor. Gregory sold into one of our food buy distributors, and whether we get that regardless of whether the price was any particular number. And we would say, yes, indeed, Your Honor. We believe the main issue here, the lower court interpreted Section 2 to impose a price component all the way through the entire contract, even in those provisions where a price component is not included. So, for instance, the particular place where this is important is in paragraph 19 of the agreement, and that would be in on 1562 of the appendix. The contract begins on 1559, goes through 1562, the main part of the contract, and then there are several attached. In the Agreement 19, it very specifically says, unless otherwise agreed to by the parties in writing, this agreement shall apply to all invoices, purchase orders, and other documents of purchase which food buy or a food buy distributor purchasing on behalf of a committed customer may place to the seller, on which seller may generate as a result of a product request for the producers or other items purchased from seller on behalf of a committed customer. Then there's a sentence there about conditions applying into those orders, Scarlett. And then it says, this agreement shall apply to any purchase. There's no qualification there. It doesn't say purchase at a particular price or anything along those lines. It says this agreement shall apply to any purchase and sale transaction between seller, that would be Gregory Packaging, and food buy, comma, a committed customer, or a food buy distributor purchasing on behalf of food buy or a committed customer. And the contract goes back, I believe it's in paragraph 6, Your Honor, and defines who's a committed customer in this. And a committed customer is someone on a list. It's not someone paying a particular price. So if you look at paragraph 6, which would be back on, excuse me, it's paragraph 3, Your Honors. I apologize for misstating the paragraph, but it's on 1559 of the appendix. It says there, the term committed customer shall mean a client of food buy that has agreed in writing to authorize food buy to negotiate commercial terms, terms of purchasing contracts on its behalf, or it is outsourced all or a portion of its purchasing functions to food buy by written agreement. A list of committed customers as of the date hereof is attached to as attachment B. And if you go over and look in B, it's strictly a list of customers. It doesn't say how much they're paying, what they're buying. There's no qualification as to who is a committed customer. They're defined on the list. You actually go look at the list. I think there's another provision later on. It talks about how it applies to a committed customer includes all persons in a group. So if one in a group is there, it counts also for a group of companies.
Mr. Wood, let me ask you a question. As I understand the brief from opposing counsel, they argue that the interpretation that Food Buy gives now was not the course of conduct that the parties engaged in prior to the litigation. You know, what's your response to that?
That's incorrect, Your Honor, and I was going there after I talked about the provisions, but I'll go there straight now. If you look, very interesting, right at the beginning of the negotiation for the original contract, there's a series of testimony about that. That was a negotiated contract. This discussion starts at Appendix 790. The gentleman negotiating for us was Mr. Salado, and he sent a draft out, and then Mr. Goulet, who was negotiating on behalf of Food Buy, sent a red line with items to negotiate. He had 18 ideas that he wanted to do. And Goulet, his email at 795 indicates they had legal counsel they were consulting to. Neither of these companies are sophisticated or, to use the colloquial expression, rude. They know how to negotiate. And Mr. Goulet expressly asked about excluding some people from the customer list. There was a proposed committed customer list, proposed distributor list. And we said, well, these are on our thing. We want to keep them on there. If you can show us a reason why, we will take them off. And in fact, we took some people off the list so that they would not be charged for cases sold to those people. Med Assets was one of them. If you look on the committed customer list, which is attachment dated to 1566 of the appendix, one of the groups that was talked about was Navigator. And if you look at Navigator, what's interesting is EPI, we were going to charge if the distributor who's listed on C sold to a committed customer on B, we were going to get an allowance for that. But we agreed with them on B, attachment B. If you look in the second column, about a third down, one of the negotiations that occurred right up front was that we excluded Tidewater. Tidewater was a group that they had a separate contract with, and they asked up front, we need that. And as part of the negotiation of the pricing, the complete contract, we agreed to exclude that. We didn't have to do that. We could have said, no, firm down, we're going to collect an allowance on that. They could have accepted the contract with that, and then if it turned out bad, they could have terminated without cause and significance. They chose to go forward, understanding that, but for the agreement, we would have charged. There's another example in that same negotiation. Right up front, there was a distributor who was very important. Apparently, they had existing relationships. The distributor called Gordon Foods, I believe was the name of it. I just have Gordon in my notes, and the second name is escaping me at the moment. If you look at, they wanted Gordon out of the contract. But we had relationships, again, with Gordon, and a debate went on about whether we were going to get allowances for the Gordon situation. And what was the end result? If you look at attachment D, which governs allowances, there was a specific negotiation right from the beginning, and we made an exception for Gordon. But interestingly, it wasn't an absolute exception. There was essentially a runoff where they could not be billed for cases sold through Gordon as a distributor to a committed customer, but instead, up through October 1, which was a few months from the effective date of the contract, they would have a chance to wrap that up. And Gordon came in, and they got charged for every Gordon case. Because after October 1, as it says at 1572, it was a distributor. If it distributed to a committed customer, which is our interpretation of the contract under paragraph 2, they would do it. Yes, Judge Qualbaum.
Yeah, Mr. Wood, I want to kind of go back to the beginning. I think I understand your argument about your view of the contract interpretation, and I think I understand the other GPIs. If hypothetically we think the contract is ambiguous, the district court has cited to extrinsic evidence alternatively that supports his finding about how the contract should be interpreted. If we assume that the contract is ambiguous, do we review his evaluation of the extrinsic evidence de novo or for clear error?
You would review factual findings about something under a clear error standard or a substantial evidence standard. There's some evidence thereof. You would not review that itself de novo, but we would say, you look at the order, the first 23 paragraphs of the order have an introduction, and then they mention a couple of paragraphs in the contract. But instead of going through the contract and saying, contract means X, how do I make this contract all hang together? He then switches into what you're talking about, which is fact-finding about relationships, and then uses the fact-finding about the relationships to then interpret the contract. You begin with the terms, the words of the contract, and then you would go to relationship. If there's a specific finding where he says relationship was Mr. Goulet, for instance, said X, and my guy said Y, and he picked one as a matter, that would be a clear error finding, I would agree. But I believe a lot of the findings were influenced at the beginning by an incorrect interpretation of the contract. And I believe that needs to be taken into account.
What's the purpose, under your view of the contract, of the non-solicitation provision?
I'm glad you asked, Your Honor. There were two questions. They twice said two of our people didn't know, but if you actually look at the question, one of them is at 203 in the appendix, and the other is at I take that back. One of them's at 827 of the appendix, and the other's at 864, carrying over to 865. Our two people said, I don't know. But the reason they said that is the question was asked in a funny way, where it appeared that he was asking if Gregory made a deal directly with a customer, what's the point of this? And that's not the way this contract operates or employs. But here's the meaning of it. Once they get access to our customers, the non-solicitation agreement is to keep them from saying, hey, look, I'm paying $150 under this contract. Let's cut a side deal and I'll get out of the food buy program and I'll sell it to you for $1.45. That's why it's like that. If you had that kind of a direct deal, or if they said, send it to this non-food buy distributor, buy it through them, not through them, go distributor over here, and I'll give it to you at $1.45 and save you all this trouble, or to cut a deal of some kind. That's what the non-solicitation is designed for. And I noticed one of the responses said I'd defer to legal. So there is legal's interpretation of what the non-solicitation means. It's not meaningless. We did not want them coming into our agreement and being exposed to our customers and then cutting deals on the side and then leaving our agreement and taking customers out of our program. That's what the non-solicitation is about.
Counsel, if I could, is it food? Thank you, Judge Agee. If I could, counsel, was it Food Buy's position that any customer on the committed customer list, if they bought some of Gregory's products, that an allowance was taken, whether it was through the Food Buy program or not?
It would have to be from from one of the Food Buy distributors. So if Gregory sold into a Food Buy distributor, and that Food Buy distributor provided the juice to a committed customer, our position is we were entitled to an allowance for that case of juice. And the out on this, if it proved to be unmarketable or unreasonable, was a 60-day no cause exit from the thing. It was not like they were locked in perpetuity. It's a classic loss leader situation, Your Honor. It's a negotiated situation, like I pointed out earlier. If you look at the Gordon Foods dialogue, which basically runs from 7, particularly at 805, 806 of the appendix, 808, 810. Actually, it starts about 801, 802. We discussed, if we agree with you to exclude Gordon, we're going to lose X. We need to make that up somewhere in the contract. And we worked that out. And we came up with the compromise of October 1. But in the absence of notice, they wanted to compromise. There was something, they had some kind of an alternate arrangement. We believe by the terms of the contract, Section 19, we were entitled to an allowance on that case of juice. And again, if it became commercially oppressive to them, it's an easy out, 60 days and you're out. And you would lose.
Judge Cleed, has that answered your question?
It has, Judge Agee. Thank you very much.
All right. Thank you, Mr. Wood. You've got time left on rebuttal. Mr. Ferguson, we'll hear from you.
Thank you, Your Honor. And may it please the court, I'm Russ Ferguson, representing appellee and counter-appellate Gregory Packaging Incorporated. There are really two issues here that the court reviews de novo. That's the interpretation of the contract and whether the factual findings in this case rise to the level of an unfair and deceptive trade practice, which is a matter of law. I want to pick up on the contract issue just because that's what we've been discussing, and particularly to answer your question, Judge Agee, is did the court consider the conduct of the parties? And the answer to that question is unequivocally yes. And if you look at page 1516 of the joint appendix, there's a nice list there where the court went through the conduct of the parties and said, here is the conduct, here are the actions that informed the interpretation of the contract. Now the court can look at...
In order for the district court to have considered the conduct of the parties, it first would have had to have concluded that there were ambiguous parts of the contract that required extrinsic evidence.
No, Your Honor.
No?
No, Your Honor. The district court, I believe, did take that stance, but I don't believe that's correct under the law, at least as North Carolina would see it. And if you look at the North Carolina Court of Appeals decision in Bickett versus McLean Securities, they looked at it in an unambiguous contract, and this court has twice looked at an unambiguous contract and said, we must look at the conduct of the parties during the course of the contract. And this court said that in Maersk Line in 2008, and earlier in that in Management Systems Associates in 1985, this court said the conduct of the parties as they interpreted it during the contract is subject to great, if not controlling, influence. So I do believe the court can get there before finding this contract is ambiguous. And of course, both parties here do find this contract is unambiguous. Now, the couple other points I want to...
It's unambiguous, but unambiguous in different ways to the two parties.
That's correct, Your Honor. We both read it unambiguously, but come out with a different conclusion. And ours is the conclusion of the district court.
Which might lead a court to conclude that there was some ambiguity there.
It could, Your Honor. It absolutely could. And if the court finds ambiguity here, that would certainly be harmless error because the district court went to that next step and said, well, even if it were ambiguous, here's all the factors I looked to, and I interpreted this contract to find that it was interpreted the same exact way as the district court did. And that is that food buy does not get a volume allowance for cases that it had nothing to do with. And I think the key fact that's perhaps missing there, at least in the briefs, is that Gregory Packaging didn't know that food buy even would have knowledge of those cases. Gregory Packaging didn't know, and this is in the findings of fact of the district court, Gregory Packaging didn't know that food buy had gone to the food distributors, cut a separate deal, and said, give me all your data for every case Gregory Packaging is selling to our committed customers. So in a normal commercial relationship, food buy would have knowledge about the cases that food buy sold. Here, food buy had knowledge of cases that food buy didn't sell and charged a volume allowance for those cases. Let me take another couple minutes on the contract since we were talking about a couple other points. And one is the exclusions in the contract. Well, when you exclude someone from the contract, like say Navigator was excluded or Gordon Foods was excluded, that means a volume allowance is not earned on those cases even when they're purchased through the food buy program. That means that the rest of the contract applies, but it doesn't because you've specifically excluded it. Now, in the case of Navigator, the court found, and this is at paragraph 27, page 1476 of the Joint Appendix, that food buy charged Gregory Packaging for Navigator anyway, even though they were excluded. And on the Gordon's exclusion that my friend on the other side discussed, the district court found that Gregory Packaging was charged for cases of juice through Gordon's that were never purchased at all, just wholesale made-up cases. But what the exclusions don't address are cases that are already outside of the contract. And if you look at paragraph 2, and I know this is in the brief, so I won't belabor the point, but paragraph 2 sets out at the very beginning of the contract to what this contract applies. So paragraph 1 is the term. And you get to paragraph 2, and the language is very clear. It says this agreement contains the terms and conditions for. Right? So what follows is what the terms and conditions of this contract apply for. And there are 4 prongs. 1, a product that's listed in the contract, the product specified in attachment A. 2, at the prices specified. 3, sold by seller to a food buy distributor, which is also defined and listed. Purchasing on behalf of a committed customer, which is also defined and listed. Now, the key prong here is the second prong, the price prong. Because if you're not buying through the food buy program, you're not buying at the food buy price. And that's a factual finding the district court found. And so the rest of this contract is the rest of this contract doesn't apply to a purchase that doesn't satisfy those 4 prongs. Now, my friend on the other side points to 2 sections. I'd like to briefly touch on them both. The first is the non-solicitation section in paragraph 18. And the question is right. Why would you have a non-solicitation provision if Gregory Packaging could go, cut a separate deal, and food buy would get a volume allowance anyway? Why would they care? It's less work for them. But even more telling is, I think, the language of the non-solicitation provision. Because if you look at it, it says, during the term of this agreement, absent prior written consent from food buy, seller will refrain from soliciting any food buy committed customer to procure products from seller, and here's the clear language, outside of the committed customer's relationship with food buy. That language contemplates a situation where a committed customer on the list is going outside of food buy to buy Gregory Packaging's products. Now, obviously, food buy doesn't want that happening, and that's why that provision is there. Now, if Gregory Packaging doesn't solicit that business and a customer buys outside of the food buy program, then obviously a volume allowance is not owed, or that provision would not be there. Now, Section 19, Your Honor, is obviously at the end of the agreement where there's kind of the non-operative terms, and it's limited by Section 2. The whole agreement only applies to those transactions that come into Section 2. But even if you look at Section 19, which is the integration clause, what you're really looking at is language that's defining an order. An order is invoices, purchase orders, other documents, purchases which food buy, blah, blah, and it goes on. And it talks about items purchased from seller on behalf of committed customers. Well, remember the committed customers is defined in Section 3. And if you look at Section 3, the definition of a committed customer is a client of food buy that has agreed in writing to authorize food buy to negotiate the commercial terms of purchasing contracts on its behalf. And I don't think anyone can say price is not a commercial term in a contract. So a food buy distributor is not purchasing on behalf of a capital C committed customer unless they're buying at food buy's price. Now, the interpretation of the contract is before you de novo. So is whether the clear factual findings of the district court rise to the level of an unfair and deceptive trade practice under North Carolina law. Now, the facts themselves are very clearly under a clear error standard of review, the facts themselves. But it is a question of law as to whether those facts make up or amount to an unfair and deceptive trade practice. And it's not only a question of law, it's a question of state law. And this is a place where the North Carolina state courts have spoken. The most stark unfair and deceptive trade practice, I think there are a lot, including misrepresentations, which are fairly clear. But the starkest is the systematic overcharging, right? There can't be a question that the district court found systematic overcharging here as a factual matter. There may be a question about the interpretation of the contract, but given its interpretation, there was systematic overcharging. Well, the North Carolina Court of Appeals, in a case called Sampson Blade and Oil in 1987, said that systematic overcharging is an unfair and deceptive trade practice. How did they define overcharging? Charging more than a contract permits. There was a contract there between two parties, and the court said that's an unfair and deceptive trade practice as a matter of law. Now,
So
that was
counsel, is it your position that if there was overcharging based on an incorrect but innocent interpretation of the contract, that North Carolina law classifies that as unfair and deceptive trade practices?
Yes, Your Honor. And North Carolina courts.
Does that case you just said say that? I mean, I know it talks about systematic overcharges, but does it say overcharges pursuant to incorrect but unintentional interpretation of the contract?
No, Your Honor, that case does not say that. But there are other cases from the North Carolina Supreme Court that say good faith is not a defense to the Unfair and Deceptive Trade Practices Act. And that's what FUBA is saying. They're saying, well, we interpreted this contract in good faith, and we can quibble with that, but we interpreted it in good faith and misinterpreted it. But the North Carolina Supreme Court has said over and over again, in Marshall versus Miller, they said it in the 1980s. In 2000, they said it in Gray versus North Carolina Underwriting. that good faith is not a defense, and they say the intent is irrelevant. Whether someone acted in good faith or bad faith has no bearing on unfair and deceptive trade practices in North Carolina. And I know that is different than some other states.
Counsel, let me follow up a little bit, back to the beginning of this discussion. The district court order, spends a lot of time on the economic loss rule, and I understand your position with respect to that. But then it has a fairly brief section, if you will, an alternative section about aggravating circumstances, where there is still, arguably, dealing with the tortious interference claim. Maybe not as hard for me to tell, quite frankly. And so, if you are right on the economic loss rule, why do you say, when we have a fairly unclear provision of the order on that we should make a ruling as a matter of law to you, as opposed to let the district court consider that, without the, confusion of kind of commingling with the tortious interference claim?
So thank you, Judge Quattlebaum. I think I understand your question. So the district court made a legal conclusion that there were no aggravating circumstances here. And at least I think that's what the district court was trying to do. I think you got it right. They conflated the two concepts. The district court conflated economic loss rule with aggravating circumstances, which are separate. But that is a conclusion of law that you review de novo, and it's a question of state law. And the state has said that, one, systematic overcharging is an aggravating circumstance, because they found in cases with contracts that that's an unfair and deceptive trade practice. They've done the same thing in cases where misrepresentations. And I think the district court's factual findings made a pretty clear finding of a misrepresentation. They said the employee in charge of the relationship was saying internally that Benjamin Foods, which is a distributor, was not following their pricing and shouldn't be entitled to a volume allowance, and at the same time turning around and saying to Gregory Packaging, well, they are using your pricing, which is not only a misrepresentation in itself, but it's also concealing Foodbuy's breach, which is another aggravating circumstance, because instead of saying, you're right, they're not using your pricing, but you owe us a volume allowance anyway, they're trying to keep the scheme going by saying, well, they are using your pricing, and that's why you owe us a volume allowance, not because we interpret the contract to say we get one anyway. So all of those things, as a matter of law, Your Honor, are an aggravating circumstance, and I think the district court just got that wrong. Now,
well, if there's evidence in the record that would support a conclusion that there is no aggravating circumstances, is it your position that we can't consider that evidence to determine that there was some evidence, substantial evidence, from which the district court could have found the absence of aggravating circumstances? I understand your argument that there was evidence that supported it, but if there's evidence in the record that would lead to the opposite conclusion, why can't we consider that in determining whether we should affirm the district court or not?
Well, you absolutely can, Your Honor. You can consider whatever evidence you'd like in making a de novo determination of whether there are aggravating circumstances or not. What I'm saying is there are factual findings of the district court that are a per se unfair and deceptive trade practice under North Carolina law, and in that case,
okay,
it would be error not to find it. So, and if you look at the top shelf management case, which is a Middle District of North Carolina case, they say, and I'll quote, intentional misrepresentations are per se violations of Section 75-1.1, which is the North Carolina Unfair and Deceptive Trade Practices Act. And I think it's clear the court found a misrepresentation. There's also factual findings outside of the contract. For example, and I know it was a small part of the damages, but the court found that there were cases simply made up, as the court put it, that were never purchased at all, for which a volume allowance is owed. That's at page 1,503 of the joint appendix. Now, I don't think either interpretation of the contract says that a volume allowance is owed for cases of juice that were never made. And so that is action outside the contract, and I think that's another reason you could find an unfair and deceptive trade practice here as a matter of law. And keep in mind, it only takes one, right? You don't have to find systematic unfair and deceptive trade practices. You only have to find either an unfair trade practice, which is broader, or a deceptive trade practice. And I think the district court found both here. And keep in mind that the North Carolina courts interpret the Unfair and Deceptive Trade Practices Act liberally. And the Fourth Circuit has noted that in the Gilbane case, and more recently in the South Atlantic Limited case, that it's implied limited, and that even a truthful statement can be an unfair and deceptive trade practice if it has the capacity to mislead. And I think the district court did find that, and at 1496, the judge says that Food Buy acted all along as if they were interpreting the contract as Gregory Packaging does. Yet, when it gets, they weren't at all interpreting the package that way, and instead, to the tune of millions, were charging for volume allowances that were not owed to them, and that Gregory Packaging did not even know they knew about. I see my time's running out, and since that seems like a fair stopping point, I'll stop there, Your Honor, unless you have any other questions.
Judge Quattlebaum, Judge Klee, have any more questions at this point?
No, thank you, Judge.
All right. Thank you very much. Mr. Ferguson, we'll hear again from you shortly. Mr. Wood?
Yes, Your Honor. Addressing the thing, I believe the economic loss rule does apply here. The briefs point out there is no North Carolina Supreme Court case on that. I did locate one Court of Appeal decision, and I will admit that it itself is ambiguous. In some regards, it says it's reversing or it's upholding the case itself. The signature construction development 2016 is the date. It is, and I forgot to write down the thing. I apologize, Your Honor. Hang on, I might have it with me. I do not, and I apologize. I didn't write the site down, but it is a case out of the North Carolina Court of Appeals. It does say that it is affirming a decision by the trial court in that case. There's also the Coker v. Daimler Chrysler case, 204 Westlaw 32676, another state court. That's a trial court case. Came out of the Superior Court, the business court. It was affirmed on other grounds by the Court of Appeals at 617 Southeast 2nd, 306. The Court of Appeals did not reach the ELR, the economic loss rule question. There have been several district courts in South and North Carolina that have ruled that way. Judge Osteen in Bushian versus Daimler Chrysler 411 F sub second 614 2006 applied the economic loss rule to a UTDPA claim. Mecklenburg County versus Nortel Government Solution 208 Westlaw 406319. That's again a Western District case. Judge Mullen applied it. So I believe the ERL can be, the economic loss, ELR, the economic loss rule can be applied here. There are several decisions that have done it. I will say there is the case, Ellis v. Louisiana Pacific Corporation by this court. It's at 699 F 3rd 778 acted cautiously. This was in 2012. And they ruled, despite a lot of similar type findings you had here, that there was not substantial aggravating factors. It's not just, I find a factor that's aggravating. They have to be substantial aggravating factors. And I think this goes to the point that Judge Quattlebaum was making. There is evidence here that they weren't substantial. Opposing counsel even mentioned there was some cases that were charged for that there's some evidence about maybe cases that were charged for that were never shipped. And he himself said it was a small amount of those things. Those kind of errors were always corrected when they were brought to the attention of GPI. I gave an earlier instance when this contract was negotiated and renegotiated in 2013. They brought to our attention we had a new committed customer because of a merger. We believe we were entitled. Yes, Judge Quattlebaum.
Mr. Wood, if given the way the order is drafted, if we disagree with your view on the economic loss rule, I asked this to your colleague, I want to ask this to you too. Given the limited and maybe even a little confusing discussion of aggravating circumstances, is the best approach for us to, decide, either based on, the evidence in the record that there are aggravating circumstances, or if we felt there was evidence to the contrary as well, is the appropriate thing for us to do that, or to remand it for the district court to be able to, address that specific question without any influence of the tortious interference claim?
I believe, Your Honor, that y'all could address it. Look at the evidence. That is the meaning of de novo review. I don't think it has to go back. You could send it back, but I don't believe it has to. And I think you can do it based on your decision in Broussard versus Meineke Muffler, 155 F3rd 331. Talked a long discussion in there about what it takes to get you past the substantial aggravating factor standard. The court, and speaking through Judge Wilkinson, makes it clear that, look, a UTDPA claim shows up as boilerplate in every breach of contract case that comes into the court or gets filed. And you've got to have more than just breaches of the contract, which is all they've alleged, breaches of the contract. You didn't service it the right way. You were charging this, not that. You've got to have more than those. You've got to have something bigger that has to be substantial, not just, as I believe counsel said, if you have one little finding of that, you can tag somebody for triple damage. I believe the Broussard case would allow you to proceed and affirm the court, because I believe at best you've got mixed evidence here and should affirm the court. He's looked it over. He heard the witness. He knows whether there was evil intent that needs to be punished with a triple damage injury, and he's reached the conclusion there is not substantial aggravating circumstances. Everything here is skewed about what the contract means. It all turns back to that. What information did you have to look at? Look in our agreement, it says we could rely on what the distributor sent us, which was, I sent cases to this customer who's a committed customer of yours. We billed for those. Now they're saying, no, you should only have billed for ones that were charged a certain price. But that contradicts our contract, which does not allow us, it said the contract itself says all that matters is what the distributor, the info sent to the distributor, make the call.
All right, Mr. Wood, you're beyond time now. Judge Quattlebaum or Judge Klee, anything else for Mr. Wood? All right, Mr. Ferguson.
Running.
That's okay, Mr. Ferguson.
My clock went out, Your Honor. I can't see the clock. I apologize.
Thank you, Your Honor. Thank you, Your Honor. So on the economic loss rule point, Mr. Wood is correct that the federal courts have simply said that the North Carolina courts have not reached whether the economic loss rule applies to the Unfair and Deceptive Trade Practices Act or not. But that is not the same as saying, and that's true, the North Carolina courts have not said the economic loss rule does not apply to unfair and deceptive trade practices. But at the same time, they have not applied it, and they have been given the opportunity time and again. So much so that in 1990, the Court of Appeals had to come out with an opinion in the J.M. Westall case, and they had to say, you don't have to have a contract in order to have an Unfair and Deceptive Trade Practices Act. Because as the Middle District noted in the CBP Resources case, that unfair and deceptive trade practices most often arise in commercial relationships. And because there's a commercial relationship, there's often a contract. So in all these cases where the North Carolina Court of Appeals has seen contracts and seen an Unfair and Deceptive Trade Practices Act claim, they have never applied the economic loss rule to it. In the Garlock case, they said that the breach of contract and the Unfair and Deceptive Trade Practices Act claim can be based on the same conduct and the same damages. That's going about as far as you can from the economic loss rule, which applies to torts. Now, that makes sense to me, because if you think about the economic loss rule and the purpose for it, in North Carolina law, courts, the North Carolina law, the economic loss rule applies when there's a breach of contract and a tort, because what the courts say is two parties to a contract can allocate that risk. You don't need the tort system, which would just pile on damages, because the parties have already allocated the risks between them. But for an unfair act or a deceptive act, you can't really allocate that risk between the parties. By its very nature, you don't know about a deceptive act. So it makes sense that the economic loss rule, which applies to torts, doesn't apply to the Unfair and Deceptive Trade Practices Act. I'm glad my friend brought up the Broussard case. I think it's interesting case, obviously a seminal case in this area, yet I don't think it was cited in either of our briefs. And I think that's because the case is so different, but as is often the case when you have a very different case, sometimes that brings out a similarity too. So in the Broussard versus Meineke case, the breach of contract there, and I know it was a complex case, but the thrust of the breach of contract there was that the franchisees paid 10% of their revenues into an advertising fund controlled by the franchisor. And the franchisor used that advertising fund to sue their advertising agency instead of using it for advertising. And the question was, is that a breach of contract? And there was an Unfair and Deceptive Trade Practices Act claim, and this court found there was no aggravating circumstance. And that's true, right? All you have is a breach of contract. Now, the difference in that case and this is this. If in the Broussard case, Meineke had used $1.1 million and sued an advertising firm and not told the franchisees that, then that would be the concealment of a breach, and you would have an Unfair and Deceptive Trade Practices Act. You didn't have that there. Had Meineke said, you owe 10% of your revenues for this advertising fund and sent them invoices for 20% of the revenues every month, you'd have systematic overcharging. You'd have an aggravating circumstance as a matter of law. In Broussard, you didn't have those facts. You had a breach. There was a question about whether it was a breach or not. That question was resolved, and there was no aggravating circumstance at all. Unlike here, where you have a number of aggravating circumstances as a matter of law. And those are not limited to overcharging and misrepresentations. The district court found a number of factual findings that Foodbuy concealed its breach, that it refused to disclose its breach to Gregory Packaging, which this court said in South Atlantic is a unfair and deceptive trade practice. There are a number of factual findings that Foodbuy withheld data from Gregory Packaging, and that's more important than it seems, because Gregory Packaging could not even tell who was overcharging it or how, because it didn't have the data to do it. And what happened, and this is in the trial transcript, is it saw its sales remaining somewhat flat and the invoices from Foodbuy going up. But at first it didn't know it was Foodbuy. It didn't know what was happening. And it went to every other GPO, went to every distributor and said, give us the data and let us see what's going on. And by the process of elimination, Foodbuy is the only one that wouldn't give it the data. And that's how it figured out it was being overcharged by Foodbuy here. And still at that point, it didn't understand how or the interpretation of the contract or how Foodbuy would even know about those unfair and or about those cases that were sold. And that is unfair and deceptive. And through all of this, it wasn't just deception, but Foodbuy knew the effect it had on Gregory Packaging's business. And the district court found a couple times, and it's at 1494 in the order, and there's a couple paragraphs there, where Foodbuy admitted that if on a school bid, given the margins, if they were paying a volume allowance to Foodbuy on those cases, Gregory Packaging was losing money and admitted it would be detrimental to their business. But they did it anyway. Thank you, Your Honor.
Thank you very much. We appreciate counsel joining us by video today. Your experience, if you've been to the Fourth Circuit before, is that you would know that at this point we'd be coming down to shake hands, which obviously we can't do under the current circumstances. So we'll thank you again for your excellent arguments and hope that we'll all be able to meet in Richmond at some future date. And with that, I'll ask the clerk of court to adjourn court for the day, and then if the judges will remain on the video conference.
This honorable court stands adjourned. God save the United States and this honorable court.